The margin for each state, therefore, remains wide. And the court has even said that it is a considerable margin of appreciation. Which means, and I think that is quite normal for a topic like this one, that the responsibility really is very much in the hands of the national authorities. 3. What characterizes the prohibition of euthanasia is two things. It forms a protection of, what characterizes this prohibition is, in the first place, it forms a protection of the individual's rights against the will of that individual. We are speaking of the right to claim euthanasia, so it's someone who wants euthanasia. And secondly, it's a blanket ban. It's a prohibition. There are no exceptions. Now, these characteristics do not mean that the prohibition cannot be justified. But, and now I come to my fourth point, the fact nevertheless remains that it is for the legislature to examine whether the reasons to prohibit euthanasia are still sufficiently strong to outweigh the individual's right to personal autonomy. When a balance is struck, it is not struck once and for all. And especially this matter, like any other ethical matter, is one that should be kept under review by the national authorities, taking into account the developments in science, developments in society, etc. The court has said that explicitly with the situation of transgender people, and also with respect to issues such as artificial procreation. I think that the same can be said about issues such as euthanasia. So that's the role of the legislature, to see whether there is a need to revise the balance of interest as it has been adopted. And let me say one thing about the role of the legislature. Where restrictions are imposed on individuals and where they follow directly from the law, not from an individual decision taken by an administration or by a court, the quality of the decision-making within Parliament will be for the European Court of Human Rights a very important element in its review of the necessity of the interference. So I would say it will be very important for Parliament to do the matter, to take its decisions in a well-informed way. There is a need to be well-informed about the developments in society, in the medical science, etc., etc. My third point. Assuming that euthanasia can be considered compatible with the Convention, because if the answer is no, then we don't have to go further. But assuming that euthanasia can be considered compatible with the Convention, and assuming that the legislature would decide to decriminalize euthanasia, what are then the requirements following from the Convention? There are two sorts of requirements. On the one hand, it is necessary to provide for safeguards for the right to life. The state has a duty to protect vulnerable persons, even against actions by which they would endanger their own lives. And so where a country adopts a liberal approach with respect to euthanasia or assisted suicide, appropriate implementing measures for such an approach are needed, in particular certain preventive measures. And on the basis of the case law of the European Court, notably with respect to the withdrawal of medical treatment, I would say that three factors in particular come into account. One is the quality of the domestic legal framework. It must be sufficiently clear to regulate with precision the decisions to be taken by the doctors involved. The law must determine the categories of the persons to whom the law applies and the conditions that must be fulfilled. Should the person be in an incurable condition? Does the law apply only to physical or also to a psychological condition? Should the person be at the end of life or not? All sorts of questions that need clear answers in the law. And the law should also provide for specific guarantees with respect to specially vulnerable persons, for instance, minors. 2, the decision-making process. The decision-making process in an individual case should allow for taking into account the person's wishes, of course, but at the same time provide for guarantees against abuse. Article 2 obliges the states to establish a procedure capable of ensuring that the decision to end one's life does indeed correspond to the free will of the individual concerned. So, in drafting a decision-making process, that is designating also the persons who will be involved in that process, explaining the detailed arrangements that are needed before a doctor can take a decision that he or she will perform euthanasia. All that is needed, but I should also say that is within the state's margin of appreciation. It is the patient who is the principal party in the decision-making process and whose consent must remain at its heart. And this is true even where the legislature would decide that euthanasia is possible where the person concerned is unable to express his or her wishes. One can think of living wills, or perhaps even the patient's presumed wishes. 3, a control a posteriori. That's also a relevant factor in the assessment of whether a state complies with its positive obligation to protect the right to life. The possibility of a control a posteriori. That can be a control by the courts. One can think of criminal proceedings against the doctor. Could also be a control by a non-judicial body, in which case the question arises whether that body will be sufficiently independent from the doctors involved. But the law, on the other hand, must also make it possible to effectively enjoy the right to euthanasia once this right is created. Indeed, the effective enjoyment of the rights guaranteed by Article 8 of the Convention requires the state to provide an effective and accessible procedure allowing the person concerned to effectively exercise his or her right of access to a lawful euthanasia. The court has underlined that several times in cases of abortion, where the law in certain countries allows for abortion, but makes it extremely difficult to get an abortion in time. In particular, the consultation process between the person and his or her doctor should avoid, well, it should of course provide, I explained that, for safeguards against abuse, but at the same time should avoid to submit the whole process to conditions or perhaps penalties which could constitute a chilling factor for both the person seeking euthanasia and the doctors in the medical consultation process. The legislature